Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about eyewitness testimonies. Eyewitness under the Indian Evidence Act 1872. According to Section 3 of the Indian Evidence Act 1872, there are two major forms of witnesses: statement of witness, documentary evidence. The eyewitness testimonies are considered under Section 3 or subsection 1 of the Indian Evidence Act. This section provides a statement of an eyewitness under oath with a major evidentiary value under Indian law. In the case of Mudhu Madhurantha vs. State of Karnataka, a witness has been defined as a person who is able to provide information by oral or written depositions given in the court or otherwise. Generally, a witness is considered to be independent unless acting under coercion, fraud, or false means. Section 118 of the Indian Evidence Act states that every person should be competent to testify before the court of law unless exempted due to legal disability. Example, a lunatic person cannot testify as a witness. Another provision of the Indian Evidence Act that strengthens the status of an eyewitness in Section 134. This section lays down the provision that there is no particular number of witnesses fixed by law which can be required to prove any fact. Even one witness can be enough to prove a fact before the court of law. The Supreme Court has held that even there can be convictions even on the basis of sole witnesses. Importance of eyewitness under the law. The role of an eyewitness under Indian law is significant for the trial process and to maintain the fairness of the justice delivery system. Basically, the role of eyewitness comes into play during the initial trial procedure, where the platform of the entire case is built before a court of law. All the statements of witnesses are recorded as evidence in accordance with Section 164 of CRPC. The statements are recorded on oath, followed by three-tier procedure of examination in chief, cross-examination, and re-examination of eyewitness. As held in the case of Vikas Kumar Rurkewal vs. State of Uttarakhand and ORS, Supreme Court has examined the role of witness in the criminal justice system. The court laid down its observation that the witness play an integral role in the criminal justice system. In the same case, the Supreme Court also held that taking legislative measures for the protection of witness can contribute to conducting a fair trial. Major drawbacks of eyewitnesses' testimony. Eyewitnesses' testimony plays a vital role in the justice delivery system, but it also has several drawbacks, which makes it an unreliable source of evidence many times. In a survey under English law, it was found that inaccurate eyewitness lead to more than 75% of wrongful convictions. The same scenario goes under Indian legal system also, where every year wrongful convictions take place. The eyewitness testimonies are affected by several factors that reduce their accuracy. The identification by eyewitnesses is majorly affected by factors such as being under the extremely stressed conditions at the scene of a crime or during the procedure of identification, fear or stress due to the presence of weapons at the crime scene, use of mask, wig, or any disguise by the offender, any type of racial disparity between the witness and suspect, short viewing time by the witness during the commission of a crime, lack of observance of witness, lack of any specific characteristics of the suspect, example tattoos, marks, etc. Unreliability of eyewitness. Eyewitness testimony is affected by many factors. Even though it plays a vital role in the justice delivery system, there are several factors which can affect the observation of an eyewitness. This leads to unreliability upon the eyewitness. Focus on weapon. It is the general tendency of the eyewitness to focus on the offender's weapon. When a person is present on the scene of crime, the focus of such person is more on the weapon used in the crime, such as what weapon other person is holding, the size, color, type, or shape of the weapon pointed at him or the other victim. But due to weapons focus, the details of other preparators are not observed by the mind. Generally, a witness can recount all the details of weapon is in mind, but fails to recall exact details of the perpetrator. Such a factor of weapon focus leads to unreliability of eyewitness testimony. An environment of high stress. At the scene of a crime, either the person is a victim or not, he is under high stress. High stress puts a mind and body to survival mode, and the person's mind works for his survival rather than focusing on the perpetrator. Due to the stressful environment, a person's ability to observe accurately and to recall the event later is reduced. Even sometimes people get numb because of the fact that he is a victim, and this reduces the ability of observance. Mental trauma. Traumatic situations lead to the mental shock of the victim and witness, and due to this the accuracy of observation reduces. Any traumatic situation can result in shock such as murder, rape, assault, or robbery. Any such act can lead to the mental trauma of the person. Mental trauma puts a major impact on the minds of people, and the victim of the witness can fail to properly observe the actual offender who is committing the crime. When the testimony of such eyewitness is recorded, the accuracy of such testimonies could be low. Human memory. The human brain stores memories in bits and pieces. Even when we walk down a street, it is nearly impossible for the human brain to memorize all the details. Our brain recalls information in bits and then fill in the missing detail by itself when the memory is unable to recall. Similarly, when during the police investigation details are asked about the witness, the mind is unable to recall exact details and fill in the details by itself. This often leads to the wrong identification of the accused.